on this webinar. So welcome everyone to the Immigration 101 webinar. It's a webinar co-hosted by a restaurant and catering here, our industry body, our peak body for hospitality for our members in the restaurant, catering and cafe and the hospitality industry in general. We're co-hosting this with R&CA from Australia Migrate, who is involved with all our migration related inquiries as well at restaurant and catering. So very excited to be co-hosting this webinar with him. It's a very important topic for our industry, and particularly for this particular season. Australia is reopening its borders to international arrivals. It builds upon things such as international students, tourists, working holiday visa makers, and of course, skilled migration as a whole. And we know it's a very big concern and it's a very big topic for our members. And we know it's a big topic in particular for the skill shortage, the labour shortage that many of us are facing with staff. And so, you know, relying on not just the domestic supply of labour, but the international supply of labour is important as well. And so we're seeing quite a lot of relevance, and quite a lot of our members were interested in this topic. We had about over 130 sign-ups for the webinar. I know there are many, if not watching live now, we'll be watching the recording. And so if you're watching the recording of the webinar, a big hello to you as well. And I hope that you were able to find many topics and points relevant. So today we'll be covering our 101 on helping you to understand what is the basics of what it looks like to have international supply of staff and what it looks like to go through the visa process. R&CA will be able to walk you through those steps, those expectations, those timelines of what to expect and the costs to expect with the fees and various visa processing that is required as well. And so we will be going through that as well. And as I mentioned a tad earlier, if you've got questions, we encourage questions, pop them through in the Q&A box and we'll be able to assist. And so if I haven't mentioned yet, my name is Brendan Zhu. I'm the Manager of Workplace Relations Legal Policy here, hosting it today. And we have with us today R&CA, who is the Principal and Director of Australia Migrate, who is, you know, R&CA's a Trojan migration agent to help with the hospitality and visa options really in hospitality. He has over 20 years experience in this and has been helping our members for many years as well. And so Ian will be covering these following topics. We'll be going through the process, the options, what it looks like for you as an employer, and what are some of the challenges that you might not have foreseen or might not have known about and that you might need to know, what it looks like in terms of your obligations as a sponsor. And then, as I mentioned, we'll cover some questions. So if you've got any questions, pop them through in the Q&A box as well. And with that, I will leave it to you, Ian, to begin us on the 101 webinar.
Thanks very much, Brendan. I really appreciate that introduction. So what we're going to do today is give an introduction and a bit more than just an introduction on the whole scope and what is involved in sponsoring an overseas person. I'm going to try and highlight some of the typical issues we come across that are, in a way, a challenge that repeatedly come up. So, so you're aware of what sort of lies ahead and how everything fits together. So let's, there's a lot of material to cover and there may be a little bit of information overload. So I'm going to try and just highlight the things that would be most relevant for sponsoring an overseas person and not go into too much details about other visas that can also be used but are not as commonly used. There are different types of visas for sponsoring overseas workers, and the most popular one particularly is the 482, also known as temporary skill shortage. So when a restaurant worker, being either a cook, a chef or restaurant manager, approaches you or already has a visa, it's most likely going to be a 482 visa or a 482 visa that you are going to be applying for. That also can lead on to the next number 2 visa, which is employer nominated sponsorship visa, which is a permanent visa. But that can only apply to chefs. So we're not going to go into too much detail because that is kind of like something that we would discuss in another webinar. Then there's also one that I wanted to bring to your attention, particularly for businesses that are based in regional parts of Australia, or regional postcodes of Australia, which is called a skilled employer sponsored regional visa. So it's a little bit of a combination of a 482 and a 186. The benefit for restaurants based in a regional postcode sponsoring an overseas person is that 494 visa, which is the one in point number 3, can lead to a permanent visa and can apply to all 3 cooks, chefs, and restaurant managers. And then there's a labor agreement for premium restaurants. And also just to point out that applicants from overseas, or when I say that from overseas, that could be here on a temporary visa, can look at, certain of them can look at independent applications through the points test. But the majority of the seminar today or webinar is going to focus on the 482 visa. So we'll go on to the next slide and we'll go into a bit more detail about what that involves. So just looking at process of each visa option, if you look at pathway A, temporary skill shortage, there are 3 main steps for this application if you look at the requirement. So the visa subclass that would be granted as a result of this is called a 482. There are 3 steps in the process. Now, some of you may already have gone down this pathway before, may be familiar with it. You may have done some of it or all of it. And that's good if you've got that background. But there will hopefully be things that I'll mention that may be new for you, that will help you make a decision about whether you want to go down this pathway again. So the 3 steps are essentially that the business needs to be approved as a business sponsor. That approval has to come from the Department of Home Affairs. The Department of Home Affairs are going to be looking at, is this business an actively operating business? Is it viable to be a sponsor? So we'll go on to that in the next slide, a little bit more detail about what is involved in becoming a business sponsor. The next step in the process is that the business has to lodge a nomination application. Now, that's a separate application from the sponsorship application. In the nomination application, it's really about what the position is within the business that the business owner wants to get approved. It's not so much about the applicant, but it's about what position is it that they would like, such as can either be a cook, a chef, or a restaurant manager. There's no other options in a 482 visa to select any other types of occupations. Now, the nomination is a tricky type of application because a lot of things can go wrong, which I'll go into a bit more detail. Just to let you know some of the process of the nomination, what is involved in that. Firstly, there's labor market testing. 3 adverts have to be posted in 3 national reach websites for 28 days before nomination can be lodged, except if the person is from certain exempt countries, which we'll go into. There has to be a position description, employment contract, statement about why that position is a genuine position, and also evidence about why the person is getting paid, why the salary is a market-related salary, or how the salary is a market-related salary. So it cannot just be any amount. The minimum salary under this program is $53,900 plus super, but we always have to show that whatever occupation, whatever salary you're offering is related to what an Australian would get paid for doing the same work in that same location, meaning the same city or regional postcode. And the third part is the visa application, where the applicant has to show they've got relevant work experience and qualifications, or they could have relevant work experience in lieu of qualifications. And in addition, they have to meet the requirements of an English test, health and character checks. Now, the majority of applications we do are for those applicants that are visa applicants that are already in Australia on some or other visas, such as a student visa or a working holiday visa or such like. But it is possible also for a business to nominate or to sponsor somebody that is not in Australia yet, that could be still overseas, so long as they meet the skill level requirements of the visa application. So if you have somebody in mind that is in the UK or Italy or wherever else, it is still possible to sponsor that person. Under the 186 permanent residence visa, not to go into too much detail at this stage about it, but there are two stages. There are two pathways. One is called a temporary residence transition, where the person would have been working for you for 3 years. Now, under the current rules, only chefs can apply for a 186 permanent visa, or there's a possibility of, so they either have to be working for you for 3 years, or they can apply under what's called direct entry, so long as they have a skill assessment and have had at least 3 years of full-time work experience. So in that application, there's two parts, being the nomination and the visa application. I don't think I'm going to go into detail about the skilled employer sponsored regional visa, just to say that it's a bit of a combination of the 482 and the 186. The applicant has to have a skills assessment and 3 years of post-qualification work experience to be eligible. So while you may want to do a 494, you may find that the visa applicant may not be eligible to, on his or her side, to apply for a 494, that's a regional visa. So you may have to start on a 482 and then perhaps move to a 494 when they are ready to lodge a 494 visa. So if we can maybe go on to the next slide, Justin, Brendan, sorry. So I don't want to get too bogged down in all the detail over there. But this is now, what will it take to become a sponsor? It's typically known as to become a sponsor is typically known as a standard business sponsor. So once approved, the sponsorship is valid for 5 years, and the business can sponsor as many people as they wish during that 5-year period. So you don't have to go back and reapply to become a business sponsor. Every time you do want to nominate somebody within that 5-year period, you always have to provide a submission as to why that is a genuine position within your business that you want to sponsor that person. So it could be, for example, the business is growing, so in which case you'd have to sort of show evidence of that, or somebody has left and you want to replace that person, so that you always have to have a reason and show that it is a genuine position. In lodging the sponsorship, the department would expect to see that the business is actively and lawfully operating. So typically what we'd need to show in the sponsorship application are documents such as your latest financials, such as either the financials of 2020 as prepared by your accountant and the last 4 BAS statements that you have, or if you've already done the 2021, 2022 financials, 21 financials, then you could provide that and the last 2 BAS statements. So the department are very concerned that if a business is running at a loss, that they may not be able to afford the salary of an overseas person, and they would maybe assess that application, that business has not been eligible because they just haven't got the financial means to be able to meet the salary obligations of that overseas person. So they are looking out in a way for the overseas person, and they want to see the business is reasonably healthy, reasonably healthy condition. Now, if the business is showing a loss, it doesn't necessarily mean that we would rule it out as a potential sponsor. We can, for example, get a letter from the accountant of the business explaining why it is at a loss at the moment and what the business has done to put itself right and go into a more positive trajectory. It could be, for example, could have been impacted very badly by COVID, but now things are settling down and business is looking like it's going well, turnover is up, and the department generally will be quite sympathetic, especially if you can show that prior to that the business was doing well, but then there was a dip because of COVID, and now things are looking up. So if you can give a context for why the business may have running at a loss, sometimes it could be, for example, expenditure on equipment or renovation. So if that can be explained, generally they will accept that. Okay, point number D, besides the financials, they will expect to see business registration, trust deeds, organizational chart, quite detailed organizational chart showing not only the, they want to see that the business, that if it's a cook or a chef, there's some structure in the kitchen, that, there's a chef, there's a cook, a kitchen hand. And if they want to see on the organizational chart, who's a permanent resident or citizen, who's an overseas temporary visa holder, what positions they hold. That would be typically what we'd be lodging in the sponsorship application. Then also startup businesses trading less than 12 months can also apply to be approved as a business sponsor, but they will need to provide additional documents that businesses that have been trading more than 12 months don't necessarily need to provide. So typically we would ask businesses trading for less than 12 months to provide a menu, a lease agreement, pictures of the kitchen, front of house, supply invoices. The department will only see on the menu that it is fairly sophisticated or complex choice of items. It's not sort of, let's say very basic kind of egg and bacon roll kind of thing, but that does require the skills of a commercial cook or chef to be able to prepare that kind of food. So that's essentially what it takes to become a business sponsor. Now, the department don't really have a problem in approving business sponsorships. So long as the financials look in order, they kind of will be okay with that. The next stage would be lodging the nomination. So we can go on to the next slide, Brendan. Thanks. Now, one of the things that we always look at is when we start an application, if a client or potential client, restaurant or catering business approaches us, we always will say, we want to see the CV of the visa applicant first before we get involved in taking the process further, because while you as the business owner may have good experience with that potential applicant, we have to make sure that that person is going to meet the eligibility requirements of the visa, of the 482 visa. Because if they don't, then they're not in the game, and you're going to go through the whole process and get a disappointing result if the visa applicant doesn't meet their side of what they're supposed to meet. So it is very important for us to make sure that the visa applicant is going to be fine. And that is always not an easy process either, but it is where we would start. So the department are guided by something which is called R&CA, and it's a kind of a dictionary of occupations or a code of occupations, where the skill level and tasks of that occupation are stated. Now, that R&CA dictionary of occupations covers every single occupation in Australia. So it's a massive amount of occupations. But the ones that we would hone in on for the Restaurant Catering Industry Association type of occupations would be, as I've said, chef, cook, and restaurant manager. So we've got to bear in mind that when we're looking at a person's CV, that the elements of what that person has done are starting to overlap with what is in the R&CA code. But we're also aware that when we look at a lot of CVs written up by people from overseas, particularly I'd say more from perhaps European countries, they haven't quite got exactly the experience that the department would like as it is written in the R&CA code. But there's potential for us to present it in a way that does look more like what the R&CA code is of that occupation. So that's when we would get involved in a discussion with that applicant and see if it's possible if they did that kind of work, but they just don't know how to describe it. And that's sort of where we would start adding a lot of value in uncovering uncovering from them what they have done, but are not presenting in a way that's going to meet the department's requirements. Now, any application for a 482 visa needs either a certificate 3 in commercial cookery, plus 2 years of full-time work experience for a cook or a restaurant manager, and a certificate 4 plus 2 years of full-time work experience for a chef. In the case of a restaurant manager, obviously they don't need a certificate in commercial cookery, but a certificate in business or management is more or less what we'd be looking for. And also 2 years of full-time work experience. Now, what we also need to be clear about is that the work experience can have taken place while studying towards the certificate 3 or certificate 4 diploma. So that doesn't necessarily have to be post-qualification. It can be relevant work experience while studying towards those certificates, which is quite a kind of a gift in a way that they accept work experience while you're kind of getting trained. towards meeting the skill level requirement, which is the 2 years of work experience. But we also have to look out for that the work experience has to be the equivalent of 2 years of full-time work experience. So then we have to look at what visa was that applicant on. If they, for example, were on a student visa while they're building their work experience, they may have been restricted to 20 hours a week work experience. So we cannot count that as full-time work experience. We can only count every 2 weeks as full-time work experience. So we've got to understand what visa they were on at the time and how much of their work experience we can count towards them accumulating 2 years of work experience. And also point number D, work experience of 3 years of full-time can replace a qualification for cook, chef, and restaurant manager. So you often find people coming over from Europe or subcontinent may have had very good work experience overseas, or some of their qualifications could have been obtained through a kind of vocational course when they're still at secondary school. Not typically like we have here in Australia, where they go on to vocational college after finishing the HSC. But a lot of them do it as a kind of a arm of their studying at the age of 15, and they get a diploma in cookery or something like that, typically from France or Italy. So the department generally will accept that, but we also have to show that they have had that 2 years of work experience. But if they've got zero education in cook, chef, or restaurant manager, so long as they've had 3 years of work experience, that can replace the requirement for having a qualification. But also what I need to point out is that the level of evidence is very important to the department. So we cannot only provide an employment reference letter that firstly, as a basic requirement, would need to be written on the letterhead of the business, plus identifying information of the business and whoever is writing the reference. So not only on the letterhead of the business, a reference letter, but also they would expect to see things like salary slips, evidence of payment, such as tax returns or pay slips, or bank deposits in the applicant's account. So we don't have to show every single pay slip or every single bank deposit, but a good range would satisfy the department that that person did have relevant work experience. I would say that the department are maybe a bit more forgiving for certain nations than they are for others in terms of showing that level of work experience, but I don't want to say, that like for sure that they do that. It's just a trend that we see. But we always do try and push the visa applicants to show not only a reference letter, but also evidence of being paid for the work that they did. Brenda, perhaps we go on the next slide. Thanks. So as I said earlier, we don't usually find major challenges in getting the business sponsorships approved, so long as the business has reasonably good financials. The typical challenges are usually found in the next two stages, being the nomination and the visa. So starting with the nomination, that is really, as I mentioned before, about the position within the business. So again, that's a separate application. Now, the first thing that we have to do when we start a nomination application or start a process with a new business is, even before we lodge the sponsorship, we always say to the new business or the new client, let's get the labor market testing underway, because that's got to go in for 28 days before we can lodge the nomination application. In the meantime, we can lodge the sponsorship application. So the advertising is a real pain in the neck for everybody, and especially because it has to go into 3 national reach websites, being, for example, Seek, Indeed, Career One, Jora. Those are the typical ones. And one mandatory website, which is Job Active. It has to go into the Job Active one and any choice of 2 of the other ones. The Job Active one is a kind of a government website, and it's a very fiddly website to actually post on. You have to link it into the business owner's MyGov ID, and there's often quite a bit of messing around and time wasting to get that sorted out. Hopefully the government will change that, because everyone has problems with it. I don't say everyone, but a lot of people do. So also the advertising has to be have certain wording. For example, the salary has to be included, or the salary range. The location of the business has to be included. A brief description of the job, the skill level required for the job has to be included. So it's very important for us when we work with our clients that we help them with the advert. Firstly, they generally will write the advert and we'll review it and fix it up if need be, and make sure that all the needed requirements are in the advert. For example, salary. So we'll tell them we need to have salary, but often they may put a salary in 2 of the ads and not a 3rd ad. And if that is the case, we have to rerun the 3rd ad. So that's why it's very important for us to check that it all goes in correctly and that we save the adverts as they appear on the website. So we got them in our folders and we don't start trying to hunt them down 28 days or so later when they've disappeared off the various websites. Certain countries do get an exemption for not requiring to being required to advertise. Typically, Australia has a labour agreement with those countries, a trade agreement rather, and those countries are, as I mentioned, they're Canada, China, Chile, Japan, Thailand, Korea, Singapore. So if you have a visa applicant or somebody who wants to sponsor from one of those countries, it is quite lucky that you don't have to advertise the position but from other countries you do. UK you do, for example, USA you do, Ireland you do, and all the other countries, but for those countries you sort of get off the hook of having to advertise. Another typical issue that we sort of knock against, where it can cause headaches, is the genuine position statement. Now that is especially in the case of a fast food or casual food outlet or drinking establishment with limited food, and coffee shop or limited service restaurants. Cafes where there's a sit-down situation, you get served by a waiter, server, where the menu is quite sophisticated is fine. We've done a lot of cafes, but where it's casual or fast food, the department have got a kind of a radar for that, and it's more likely to be refused if it's that kind of establishment. We have come across some very good kind of combination fast food, casual food outlets with a sophisticated menu, and we can get those over the line. But if it's part of let's say a franchise and it's not sophisticated, it's just sort of a narrow range of food with no casual sort of eating areas, it's not going to be eligible for this visa, or for this nomination. So while the business may get approved under the standard business sponsorship, they're going to hit you on the nomination approval and they're going to trip you up, and that's where basically you're going to have a disappointing outcome. Also, another area that we have to guard against is mass production in a factory setting. That's another area that we would have to more or less steer clear about, unless the chef was a kind of a developmental chef and the range of food was quite wide. But if it's quite a narrow range and mass production, could be problematic. But we would always investigate any query that we had to see if there's a way around it. We wouldn't just knock it back without looking further into it. But by the same token, we wouldn't take it on if we thought that it had zero chance of getting over the line.
We have a couple of questions which we'll cover now. And as mentioned to everyone who's watching, if you've got any questions, put them in the Q&A section below and we'll answer. But in the meantime, we've got one from Linda and Graham, which we'll cover respectively. Linda's question is in relation to the labour market testing advertising. Can the 3 ads be run concurrently at the same time?
Yes, definitely. So long as they're on different websites, they can. And that's how we normally set it up, because otherwise to wait for the 128-day period and then after that another 28, it's going to be 3 months until you can lodge the nomination. That you can use, the department will accept the same site, for example, Seek, so long as the ad did not run concurrently on Seek. But they'll accept any other ads that were on different websites running concurrently. And also, another thing to bear in mind is that when we lodge a nomination, the ads, we have to show that the ads appeared within 4 months of us lodging that nomination. So if we go over that 4-month period of when the last ad ran, or the first ad ran, if it's out of that 4-month period, that ad is seen as not acceptable and the whole application will get refused. So it's critical that the 4-month period is when the nomination is lodged for the 3 adverts. And we've seen many, clients come to us where they've gone over the 3 months, or they've not advertised properly and the department just give a straight off refusal. They don't even have to look at anything else to do with the application. They just refuse you straight off on the labor market testing.
Yeah. All right. Well, thank you, Linda, for that question. The question we had from Graham was in relation to regional visas.
Yes.
What are the IELTS grade acceptance levels lower for regional visas? What IELTS level would they need for the regional visas, if you know the answer? If not, we can take that on notice.
Yeah, no, I know the answer. Okay, so for regional visa, that is going back to that 494 visa. Now, that 494 visa basically is a pathway to permanent residence, and that's what makes it an attractive visa for the right applicant. But in fact, the English requirement is higher for that visa than for a 482 visa. So it is for IELTS, it would be 16 each band, which is reading, writing, speaking, listening. And for PTE, it's 50 in each band of same reading, writing, speaking, listening. Where for a 482 visa, because cooks and restaurant managers are on what is called the short-term occupation list, the IELTS requirement is an average of 5 with no less than 4.5. And for chefs, which is on the medium long-term occupation list, giving a pathway to permanent residence, in a 482 visa, the requirement is 5 in each band. But for a 494, because it links you to permanent residence, there's a higher level requirement for English. Yeah.
And in relation to the regional visa as well, from Graham, can a spouse and kids join this visa holder as well?
Yeah, definitely. So with any visa application, whether it be a 482, 494, 186, whichever, even going out of that range of visas, student visas and many other, all other visas, a visa applicant, the main visa applicant can always include their partner and their children in that application. There's not an English requirement for a 482 visa for the partner. They don't have to speak any English, in fact. Yes, they definitely can be included.
Right. Yeah. And we do have an anonymous question in relation to the labour market testing. Again, can you offer a role to someone who requires sponsorship prior to completing a labour market testing?
Okay, that's a good question, and I should have mentioned it. You can look; they can work. You can do that, but when the employment contract that is signed, which is part of the requirement of the nomination application, can only be signed after the labour market testing has taken place. So if the department pick up that you've signed an employment contract in the middle of the labour market testing, they'll say that you predetermined who the applicant is going to be and you were not fair dinkum in offering the position to an Australian or a potential application from an Australian. You're already predetermined, therefore they refuse the application. So while you can offer it to them, I wouldn't put it in the terms of a formal contract, maybe a letter of intention or something like that, but that's not something that we would show in the nomination application. In fact, far from it. So we always make sure that the employment contract is signed and dated, or particularly dated after the 28 days of all the advertising.
Yeah. All right. Well, that's it for the questions for now. If you've got questions, put them in the Q&A section below, and we'll continue to answer questions throughout towards the end. But in the meantime, we'll move on to the next slide.
Okay, so typical issues for visa applications, and I probably touched on this a bit earlier, is calculating if applicants meet the work experience requirement given the restrictions for work hours on visas they may have been on, such as student visas or working holiday visas. So for example, a working holiday visa, person works, in the good old days when they could come here on working holiday visas, but hopefully that will continue or resume, I should say. They're only allowed to work for one business for a 6-month period, and then they're supposed to move on and sort of travel around Australia. But a lot of them don't necessarily keep an eye on that when that end of that 6-month period is, and they continue to work after that 6-month period. So we've got to be careful when calculating their work experience that we don't bring into the equation work experience after the 6-month period that they were only supposed to work up until in a particular employment situation. Okay, so that is very important, that first point, because and we do quite a lot of calculations about do they meet the work experience requirement given the visa they're on at the time. Second typical issue we come across is applicants having some difficulties in providing required documents that the department would expect to back up employment claims, such as employment references, salary slips, employment contracts, tax lodgements, etc. So we do come across applicants that said, look, they typically potential 482 visa applicants will say they worked on the books or they worked off the books, as if working off the books is, perfectly legal. But you often find that they worked, let's say, off the books. In other words, everyone knows what that is, but we cannot count that as work experience if they haven't got salary slips to back up where they've worked. So it comes back to haunt them in the long term if they worked off the books, let's call it, because they haven't got that work experience requirement. Another thing is that if an applicant has completed a qualification in commercial cookery from an Australian course provider and has got a certificate 3 or certificate 4, the department accept that they're at a certain skill level and they don't have to do anything further in terms of meeting the skill level requirement other than having 2 years of relevant work experience full-time, either while they studied or post-study. But for applicants where they're coming from other countries where and have not completed their qualifications in Australia, they may have completed a good qualification in their overseas country. The department have identified certain countries that they would need to undertake a skill assessment from, and those are the countries, there's a couple others. Those are the typical ones we've seen: India, Nepal, which is in point 3, India, Nepal, Brazil, Fiji, Hong Kong, China, Vietnam, Pakistan, and Bangladesh. So if a person comes from there and they've done a qualification there, and even though they may have good work experience, they have to go through another, let's call it, layer of assessment with assessing authority, which is typically Vet Assess, who scrutinize their work experience in more detail than what the Department of Home Affairs does, and would expect to see the nature of their qualifications, their references, very rigorous evidence of being paid for their work, even at a much higher level than what the department would expect. And so without that skills assessment, they would not be able to get a visa if they did not do that course in Australia. European countries are sort of let off the hook by and by of having to do the skills assessment. And another, not a major problem, but we do find that from time to time, there's an issue of not being able to meet the English fluency requirement, which is one of those tests like IELTS or PTE. You can lodge a 482 visa and without the English, and even though they'll call for it, you can still book it even after you've lodged the application. So it's not a time of application requirement for a 482 visa. But the other day I saw somebody that was from a European country and had some issues to do with what is that sort of condition that you read backwards? I can't remember offhand exactly what it is. And he's going to struggle to pass the English test. So, then his employer's got to make a decision. Are we going to lodge this application in the hope that eventually he'll pass it? But when I say eventually, the department may only give you 1 or 2 chances to pass it, and if you don't, they'll fail you. They'll refuse the visa. Now, what I can maybe just mention is what happens when you do get a refusal, either of a nomination or a visa or both. So I, in fact, probably did not put it in the slide yet, but I think I should just mention it. If a nomination gets refused or a visa gets refused, if the visa applicant is onshore in Australia, then the nomination can be lodged for review with the Administrative Appeals Tribunal, and if the applicant is in Australia, then the visa application can be also lodged for review with the Administrative Appeals Tribunal. So that is basically not the Department of Home Affairs, but it's another government body that reviews decisions made by decision makers at the Department of Home Affairs. And they basically will put themselves in the shoes of that decision maker and see if a decision can be made differently. In other words, a positive decision can be made or not. But if it's a matter of a black and white issue, then they cannot determine that the visa should have been issued where it wouldn't. For example, if the visa applicant does not meet the English requirements of black and white, they cannot change that decision. But let's say it's a matter of work experience, the AAT, the Administrative Appeals Tribunal officer, can say, okay, well, I accept that work experience is acceptable, even though the Department of Home Affairs officer may not have deemed it acceptable. But how the system basically gets clogged up is that applications that are refused, then, as I mentioned, can be taken under review. Each application for review costs about $3,000. So if it's a nomination that gets refused, that's $3,000, and a visa application would also get refused if the nomination was refused, because it rests on the nomination being refused. You cannot get a visa application approved and a nomination refused. So that would also be another $3,000. But what happens is that in reality, the Administrative Appeals Tribunal are very kind of backed up with review applications in their system. So by the time they actually get around to reviewing those applications, could be 2 or 3 years down the track from when the application was lodged for review. In the meantime, the applicant can continue working on the visa that they had, and they can gain quite a lot more work experience and just basically continue working. And that can go on, as I say, sometimes 2 years, sometimes 3 years. So a lot of visa applicants use it as a kind of a way to stay in Australia. And, you know, if there is a reason that the application can be turned around and by the review officer, they may even get a positive decision at the end of the day. Or let's say they had they didn't meet the work experience requirement, then while working for that restaurant, they can build up their work experience and then relodge it. They'd have to go offshore to relodge it, but they're buying valuable time in order to build up that work experience. So, you know, that's how the system gets manipulated in a way by a lot of review applications when applications are refused. But anyway, we don't really like to think in those terms, but that's what happens in reality. Sponsor obligations. It is important for every sponsor to be aware that when you do sponsor an overseas person, that it does carry certain obligations. Now, from time to time, and it's a bit of randomness, we could say, and unluckiness, if that's not the right word, if that's the right word, that the Department of Home Affairs can just suddenly pick on a business that they want to monitor. Most of the time, they haven't got the resources to cover even 50%. They may even cover 5% from what our experience is, not even. But they can suddenly pick on a restaurant or any business. It can be any industry whatsoever. And they will they'll send a letter, and it's called a kind of a monitoring letter, which is quite a threatening sort of a letter. And they will ask for very specific documents. So that's why it's important as a business owner to be aware of your sponsorship obligations, so that if that ever does happen, you're not going to sort of be caught wrong-footed, and you'll have basically all your affairs in order to meet their questions. So going from A to J, one obligation is to notify the department when an event occurs. For example, if the visa holder leaves your business, then you've got an obligation to inform the department within 28 days that that person has left your business. And they can then find another business to sponsor them or lodge some other visa application. It's basically up to them, but so long as you inform the department, you've done your duty. You've got to also ensure your employee only works in a nominated occupation. So if they are nominated as a chef or a cook, they shouldn't be working as, let's say, a restaurant manager. Ensure equivalent terms and conditions of employment are paid according to what was in the employment contract. Not engage in discriminatory recruitment practices. Keep records, that's very important. A lot of businesses get caught out by that, where they want to see records of payment of the visa holder as well as the other staff, but particularly the visa holder. When it says provides record and information, that is when you get that letter from the monitoring section and they'll say provide these records and information. So you've got to comply with that request. Assume all costs yourself. Now, as I mentioned earlier, there's 3 parts to the application: the sponsorship, nomination, and visa. The department expect that the business itself should pay for the sponsorship and the nomination costs to do with the business, with the sponsorship, both in relation to the government fees as well as to professional fees. Those costs are not supposed to be passed on to the visa applicant. With regard to the actual visa application part, that can be paid by either the business or the visa holder, both the lodgement fees to the department as well as the professional fees. But the first 2 parts, sponsorship and nomination, should only be paid by the business itself. Paid travel costs. This is one that does irk a lot of businesses, and understandably, but in reality, quite honestly, I've only seen it happen maybe 3 or 4 times in doing this work for about 20 years. So what happens is that if a person leaves your business, whether you've asked them to leave or they've decided they want to leave on their own accord, as the last sponsor, if they want to go back to their home country and ask you in writing to pay for their airfare back to their home country, you are required to pay for that airfare, even if they were a very sort of disappointing employee and they gave you a lot of problems. As the last sponsor, you have got an obligation to pay for their airfare, not only of them, but if there are any family members in that application or in that visa, you are required to pay for their airfares back home. It does sound scarier than it is. I've only seen it happen maybe 3 or 4 times. Okay, and then another one I've never actually seen happen, but it is an obligation: pay costs to locate and remove an unlawful non-citizen. So if, let's say, there was let's say the spouse of the person that you sponsored, his visa becomes invalid or they become unlawful, they can call on you to pay the costs of removing that person back to their home country. Personally, I've never seen that happen. And cooperate with inspectors, meaning that if they ask you for these records, you basically got to provide them. But I don't want you to get the feeling that there's all these monitors and inspectors running around. But as I say, spontaneously and randomly, you can be a business that they decide that they want to monitor. Usually there may be some background to why they, let's call it, picking on you. They may have some kind of like information that they're not happy with, and they may then hone in on that business, or possibly even one of the employees who may be disgruntled could dob you in, and that spurs them on to sort of launch a kind of a monitoring thing for your business. Okay, so the fees to lodge a visa application can be divided into professional fees like agency fees such as us, and government fees. So I'll start with the government fees first. To lodge the 482 sponsorship application, where you get approved for 5 years, the Department of Home Affairs charge $420. To lodge a nomination, there's the base fee of $330, and then it's 1,200 per year of visa that you're requesting that gets paid to the Skilling Australia Fund. So it's all in one payment, but it goes towards that Skilling Australia Fund. That is if the business turnover is under 10 million, as in the last financials of that business, or if it's over 10 million, then it's 1,800 per year. And for cooks and restaurant managers, because they're in the short-term occupation list, it's only for maximum of 2 years, but for chefs on the medium and long-term list, that is for up to 4 years. So let's say chef that you want to sponsor for 4 years would be 330 plus 1,200 times 4, so that would be 4,800 plus 330 would be 5,130 to sponsor a chef for 4 years. 3 years, 3,600 plus 330. The sponsorship, as I say, it's a once-off for 5 years. Then there's a visa application, which is 1,290 for cooks and restaurant managers because they're on the short-term list, and 2,690 for chefs because they're on the medium and long-term list. It's a higher charge. They'd also charge an additional $700 if it's a subsequent application onshore, but I don't want to go into that detail here, but it is something just to mention. 186 visas have a different charge. It's sort of $540 for the base fee and $3,000 for Skilling Australia Fund. And then for the main applicant, it's $4,115. And the 494 government fees are similar to the 186. Again, the business is supposed to pay the nomination costs, and the visa costs can be paid by the visa applicant. We have a split fee structure with 50% payable on commencement and 50% when the visas are granted. And if they're not granted, basically the client does not have to pay our second 50%. Fees generally will range from 3,800 to 4,200 in total, depending on the complexity of the work. But we work to a fixed quote before we commence, and we don't have hidden fees. So if an application turns out to be very complex, much more so than we expected, we just basically accept that, and it's part of the run, the kind of like toing and froing of this kind of business. So you always know what it is what our charges are. It's not, you're not going to be suddenly hit with an unexpected but nasty invoice. I think that's about it. Oh, yeah, just question time. Thanks.
Thank you, Ian. And as mentioned, we'll cover some questions now, which we've got a couple which we'll go through. But in the meantime, for everyone, if you have any follow-up questions beyond this webinar, beyond this Q&A section, you've obviously got myself on the IR hotline, which is 1300 722 878. But certainly get in touch with Ian from Australia Migrate, which is R&CA's chosen migration specialist as well. The website and the details are there to get in touch with him if you have any in mind. He does do free consultations for R&CA members. And if you would like a specific question or a more specific context that you have for your situation and want to get the ball rolling, we can certainly get in touch with him. For all our Victorian-based members, or any members really who are travelling to the Food Service Australia Expo on the 27th of Feb to the 1st of March, Restaurant and Catering will have a special booth there. We are stand C39. And so if you want to come and say hello, by all means, visit us. If you want to make a appointment for all things related to immigration, you've got that Calendly link there. So feel free to check out calendly.com/rest-and-cat, and you'll be able to book an appointment with Ian when he is there on the 27th and the 28th of Feb. I'll personally be there on the 1st of March, which is next Tuesday. And so if you want an IR appointment to talk about all things IR related, visit that link, which is calendly.com/RCA-IR/appointment. And you can easily book an appointment with us through those links. And it was also sent out in our various email distribution mailing lists. And so just look out for the R&CA booth at stand C39 at the Food Service Australia Expo. But we'll get to the questions now. And we had some, again, in relation to the labour market testing adverts. Sure. The first one from Peter is, do they check if you review or interview any applicants coming in from those advertisements?
No, they don't check that, which is lucky
Yep.
because it would be a huge amount of work to kind of document all of that. There's a question in the application why the other applicants were not successful, and just a general comment of didn't have the right skills or insufficient experience, or were not in Australia or something like that. Basically, they accept that, but you don't have to show any further information. Then it's sort of just a generic statement.
Yep. And if you have an applicant from an exempt country, such as Japan, the question is, do you skip the labour market testing and move to the next step? And does this make approval easier, more likely, assuming that you're already an approved business sponsor?
You still have to do the nomination application, just that within the nomination application, you don't have to evidence any labour market testing. So I wouldn't say it makes it easier. Yeah, it makes it easier because you don't have to do the labour market testing. But so long as you meet all the other requirements of the nomination and the visa, then you'll be fine. But it's not as if they are preferred applicants. It's just that you can skip that labour market testing requirement.
We have another question. So for someone planning to sponsor 10 chefs from overseas, is anonymous, who are affected by the levy that was applied every year. Does Home Affairs have a way to compensate for this, in effect, especially when the sponsor chefs decide to resign? And there's a similar question here. If you pay the 4-year SAF for a chef and the chef resigns after 2 years, does the business wear the balance of the last 2 years, or can they request a refund?
Okay, I'll have to take that under advisement in terms of research on that. But I think there is a way to recoup the number of years that you have paid for that were not used by that particular visa applicant, not applicant, but visa holder. So if they paid 4 years, you only used 2. I think you can claim back that 2 years that you didn't use.
Yep. Yeah. Again, if anyone
I'll come back to you on that, Brendan.
Yeah, not a problem.
Thank you.
Not a problem. We have one here from Graham. Any tips on how to find potential applicants in Thailand? Are there any Australian or Thai companies that find eligible staff members?
I don't really know offhand that type of answer. I would say, look, I'm sure that member has tried to advertise locally. And for Thai students or Thai, commercial cookery students, because generally they would be probably a little bit more advanced in their English than somebody straight out of Thailand. Because you may be an excellent cook, but if they don't pass the English, you can't go anywhere with them. So it's not only their cooking skills you've got to look for, but also their English language skills. But I wouldn't know specifically how you would target people outside of Australia.
Not a problem. All right. Well, that's it from the Q&A section. I hope everyone learns a lot about the immigration process and really clarified, what it looks like to actually apply and go through the process, whether you're someone who has dabbled in it a little bit or had no idea. If there is something that you are interested in, as mentioned, be in touch with Restaurant Catering, be in touch with Ian from Australia Migrate. It may seem complex, but certainly by being able to break it down to the basics, to the 101 of what it looks like to bring in staff from an immigration perspective, we're hoping that's helpful for our members. We will do a follow-up one with a deeper dive on some of these complexities. As always, if there's any topics that our members are interested in, by all means, get in touch. But until then, we'll see you at the next webinar. And big thank you to Ian for this presentation as well.
Thank you too.